You're watching the #1 program on cable news. Enter the no-spin zone on the O'Reilly Factor. The most powerful name in news. Fox News Channel.
Joining us now from Miami is attorney Mark Eiglarsh.
It's unfair to tell these people, well, you have 5 times to pass it, if they haven't been properly taught to begin.
But there has to be some. I agree with you.
Right.
Counselor, thanks very much. Good to see you.
Now you have police officers who are going to act as judge, jury, and sentencer, where they're the ones who are going to establish whether someone committed an offense to begin with, and then they're going to say, usually we send you over to the judge who decides whether this arrest is lawful. We're now going to decide, first of all, this was a lawful arrest because we say so, and now we're going to place you on probation. Bill, when faced between jail or probation, these people will grab probation, has appointed competent counsel right there by their side, that they knowingly and intelligently waive their right to go to trial. You're now going to have law enforcement officers who have an interest in the outcome of the case deciding whether somebody should be convicted. Bill, I want to take exception to something the Chief said, with all due respect. There's a huge difference between drug court and what they're doing here. Drug court, these offenders who are found with a small amount of cocaine, let's say, are brought before a judge. They, again, have an attorney present. They have time to think about what they want to do. They intelligently, voluntarily give up their rights to challenge the case. In this instance, when a cop confronts a person who may be innocent, Bill, I mean, there have been people in our system, I think even the Chief would concede, that are actually innocent.
Then she doesn't have to sign a paper.
Bill, confronted with either going to jail or signing a piece of paper. Not going to stand for the judge going below the guidelines. I think the judge blew it on this one. On the Walker case, you had a positive urine for both marijuana and cocaine with a history like Walker's. That wasn't
violating Mr. Limbaugh's privacy. Joining us now from Miami is Mark Eiglarsh, a criminal defense attorney who's closely following this situation.
The issue is the manner in which you choose to investigate. Before you look at someone's personal records, are there other ways that you can prove the case? There's records, I'm sure, at the pharmacy of which doctors issued which pills and how many and over what period of time. You've got apparently this cooperating maid. Before you look at someone's private records, the ACLU suggests, make sure you look at every
possible. Isn't this a likely suspect in this?
There's no question she's a likely suspect. Here's a woman who's used 45 names in the past, 15 dates of birth, 13 social security numbers, but the criminal justice system doesn't work on the premise that, well, someone must be a liar, so they must be guilty. It works on proof beyond and to the exclusion of every reasonable doubt. We learned in the Blake trial that you can feel that someone's probably guilty or may be and not find someone guilty. And in this case, with 2 snitches that just don't have much credibility, I don't know how the state's going to.
You know, Mark, you make a good point here, because when you look at the Blake trial,
News Channel.